So now we'll get started. So first of all, thanks everyone for joining the call. We really appreciate having volunteers on this project. It's been going on for 9 months now, as I said in the email, and we've done a lot of good things and made a lot of progress, but there's still a whole lot of work to do. Questions, by the way, try and keep yourself muted at any time. Questions, unmute and feel free to interrupt and ask them. The first place to start is probably just the general rules for eviction. And for those of you that have this training, this part will be repetitive, but there'll be some new information. Somebody says they can't hear me. Let me move this a little closer. Can you hear me now? Can you guys hear me? Okay.
Yeah, I can.
Okay, all right. So the first place to start is just the general rules in a non-COVID world about how evictions work, just to level set on what the basis or the basic rules are. And it's usually a two-step process. And by the way, all this is found in Chapter 24 of the Texas Property Code. So you can always look that up if you need to as a reference. But the two-step process is, number one, if you have an eviction or a reason for an eviction, which could be non-payment of rent or it could be some other type of lease violation, the first thing that the landlord does is they post something called a notice to vacate. And this is usually just a one-page form that says you have 72 hours to vacate the premises. It usually scares the hell out of everyone when they get it because they think they actually have to leave with it. That's not, in fact, true. All that does is satisfy the first step of the statutory process. And after the 3 days is expired, then the landlord can file for something called a writ of possession in the Justice of the Peace Court, which has exclusive jurisdiction to hear. So once they file that writ of possession, which is the lawsuit for eviction, then the JP courts will set that for a hearing at some point. Usually it's not very long, a week or 2 weeks out. And then you have the hearing, and as long as there was a lease violation or you are behind on the rent, then there will be a judgment for eviction, and the tenant will lose. There are no defenses under the usual normal rules. After that, the judge will issue the eviction or the writ. By statute, they have to wait 6 days, and then on the end of the 6 days, then they post another notice that says you have 24 hours to leave the property or we're going to physically remove you tomorrow. That one is the serious notice, and if you don't voluntarily leave within the 24 hours, the constable will show up the next day and remove you from the home. We've seen all kinds of cases where the landlords just throw the tenant's stuff out in the front yard or on the sidewalk. The tenant is just left there outside with no place to live anymore. So that's what happens in normal non-COVID times. What we have now is there are a few moratoriums that have come up over the last 9 months since COVID has started. Most of them have expired, so we don't need to spend time going through them. But there are two that are still relevant today. The first one is there is a City of Dallas ordinance that was passed in April. That ordinance says, and by the way, it only applies obviously to tenants that live within the city limits of the City of Dallas, not the county, but just the city. That ordinance requires that the landlord provide something called a notice of proposed eviction as a first step. And so if you go back and look at that state statute in Chapter 24 of the Property Code that said step one was a notice to vacate, and then step two is file the eviction suit. There's actually 3 steps in the statute. The notice to vacate is step 2, and the notice or the eviction suit is step 3. Step 1 in the statute says if there is an applicable law, or I think somebody's not on mute. We can hear you. If you don't mind, mute yourself. But that's step 2 and 3. What step 1 says is if there's an applicable law or if your lease requires it, then the landlord must issue a notice of proposed eviction. And they can't move on to step 2, the notice to vacate, until for the tenant to respond to that notice of proposed eviction has expired. So what the City of Dallas did was we passed an ordinance that provides an applicable law that says that the landlord must provide this notice of proposed eviction as a first step. The tenant then has 21 days to respond in writing to that notice, claiming that they have some kind of COVID-related reason for being behind on rent. And as long as they do that, then there is a 60-day period that starts on the date the notice was provided, not the date that the tenant responded, but it provides a full 60 days where the tenant can respond and provide additional information, try to negotiate a deal, get rent assistance, whatever they want to do. And then only after that 60 days is expired can the landlord now move on and post that 3-day notice to vacate and then subsequently file the eviction suit. So effectively, this City of Dallas ordinance provides a 60-day delay in most cases in the eviction process. If the landlord does this wrong, if they are in the City of Dallas and they did not provide that notice of proposed eviction and they went straight to the notice to vacate, that is a violation of the notice requirements of the state statute, and those cases will be dismissed, which means the landlord then has to start all over with a new notice of proposed eviction and then a new notice to vacate and entirely new eviction suit. So that's the first thing to always check in these cases is, especially if you're in the City of Dallas, did they follow these notice requirements? And did they provide this notice of proposed eviction and only after the 60 days provide that notice to vacate? Dallas County is a big county, and so we have lots of other municipalities within the county that are not the City of Dallas. None of them have a similar ordinance, but it's still an idea, even in those cases, just to make sure, did the landlord provide the notice to vacate properly? And I don't know what that means, Jack. I need to mute the telephone as the host.
Mark, real quick, you're the host, and I think the background audio is coming from our telephone participant, and you'll have to actually mute them as a participant. They may not be able to.
Oh, I see. I see. Got it. Okay, muted. Thanks, Jack. All right. So you still need to check that the notice requirements for the notice to vacate have been properly given, and it has to be given in writing. It has to be either posted on the inside of the tenant's residence on the front door, or it has to be given to a person over 16 years of age, hand delivered to a person in the residence. There is some alternative service where you have some posting followed by a certified mail copy. But this is all in Chapter 24. You can go look at those notice requirements for how it's supposed to happen, just to make sure that the landlord has complied. And if they have not complied with the notice requirement, not only that they gave it, but that they gave it properly, then those cases will also be dismissed. I actually had one a few weeks ago where even on the petition, the landlord posted that he had given the notice to vacate via text. And obviously that is not appropriate under the statute, and so that case was dismissed. The second, actually, before we move on the City of Dallas ordinance, I want to make one point, and this is true of the CDC order as well, that it only applies to the non-payment of rent as the reason for the eviction. So if you're being evicted because you were engaged in criminal activity, or you're destroying the property, or there's some other lease violation out there, then the ordinance doesn't apply. They don't have to give the notice. They can move straight to that notice to vacate and then file the eviction suit after the 3 days is over. And in those cases, it doesn't apply at all. You don't get that extra 60 days. We have seen a lot of landlords that are making pretextual arguments, trying to claim that there is some reason other than the non-payment of rent for the eviction. And those are very facts and circumstances based. And so you've got to really drill down with facts and present evidence to the judge to show that it's pretextual. It's not the real reason for the eviction. The landlord's just trying to skate around either the City of Dallas ordinance or the same with the CDC declaration, which we'll talk about now. So the second and probably more important defense at this point is the CDC issued an order, I don't know, 6 or 8 weeks ago now. And what it says is that as long as a person can meet certain qualifications, then they cannot be evicted until after the end of December, so January 2021. And the elements of this, there's a few of them, but the important ones are they have to have made best efforts to seek rent assistance, and they've got to provide a declaration to the landlord that certifies these things. It says, I made best efforts to try and seek rent assistance. I have made best efforts to make partial payments. Keep in mind that best efforts does not require that you actually made a partial payment. Your best efforts, if you have $0 in the bank, may still result in absolutely no partial payments. If you don't have the money, you don't have the money. And so that's part of what you may have to prove up to make the CDC declaration stick. You also have to make less than $99,000 a year if you are an individual, or $198,000 a year if you're a married couple. You can also fit under that element as an alternative if you got the $1,200 stimulus check from the IRS earlier this year, then you qualify. There are a few other items on there. You've got to certify that you understand this is not a rent holiday and that you have to pay the rent at some point, things like that. But we've got a copy of that CDC declaration on our website. That's a form document, which is, by the way, DallasEvictions2020.com. And so you can go pull that off and just give it to clients. I actually keep a stack of blank copies in my glove box in my car, so I can give them out when I'm out and about in courthouses and visiting tenants and things like that. But just go through that with your client or whoever you're talking to and just ask them the questions, make sure that they do meet all those requirements. And if they do meet them, then all they have to do is sign the form, give it to their landlord, and then that invokes the protection under the CDC order. And what the judges will do is they will then abate the case until January of 2021, which essentially just means they're suspending it until January. We'll pick it back up then, but no one's going to get evicted in the meantime. Now, that said, the landlord can contest the declaration. And so what happens here is the landlord is essentially claiming that one of or more of the things on that CDC declaration are not true with respect to that tenant. And if they have the burden of proof to show that, but if they can show that one of those things is not true, then obviously that tenant would not get the protections out of the CDC order and the eviction can move forward. Now, what's important to note about this is you can give the CDC declaration at any point prior to actually being physically removed from your home. So in fact, just today, I had a young single mom with 2 kids call. The boyfriend left her on Friday of last week. She was a stay-at-home mom, didn't pay any of the bills, had no idea the rent was even behind. And someone knocks on her door today and says, "Here's your 24-hour notice. You're being evicted tomorrow. The constable is coming." So in that situation, we had to go through and figure out what happened. Did she satisfy all these elements of the CDC declaration? It turns out that she did. And so we were able to file that, or give a copy first to the landlord. And then you need to file that with the court and with the constable for that precinct so that they know that that CDC declaration has been given, and then they won't show up to remove the tenant from the home. And so that's exactly what happened today. And in fact, when I called the constable, he was actually on his way to her apartment to evict her at that moment. So we were able to stop that one today. And we have probably several of those a day for the last week or two that's been the case. They've been very short turnaround type issues where we had to act immediately, which I'll kind of skip to the end of my presentation a little bit here and say that part of the project really is time sensitive. And the second that you take a break, or you get tired, or you want to quit, or it's too hard, just keep in the back of your mind that someone is going to become homeless as a result of you acting on that feeling. So it's very important that when these emails come through, and we'll talk about the process here in a minute, but that even if your answer is, "I just can't right now, I'm busy on something else," just respond back and tell us that so that we can move on to the next lawyer in the queue and get someone to assist that person in short order. That really is most of what you're going to have to deal with in these cases. There are not a lot of defenses. And again, these protections only apply if non-payment of rent is the only reason for the eviction. And so we got to think about those things and pull together the facts to make sure that they are going to apply to help these tenants. The next point is I want to talk about rent assistance. This program really has kind of turned into part legal work, part social work, because a lot of these people have been out of work now for 6 or 8 months. They're behind. Most people have no idea that there's even rent assistance available out there through the city or through nonprofits. They have no idea how to access transitional housing if they do get evicted, or how to get into shelters, or where they are. I don't know about any of the lawyers on the phone that have been doing this a while, but in my experience, it's probably 8 or 9 out of 10 that when I talked to them, they had no idea that writ assistance was even a thing. And so we've got to walk them through the process of here's where you go to apply. And you can find these links on our website as well and where they can go apply for rent assistance. But that's part of the process is to direct them there, have them apply for that rent assistance, and get things moving forward. The rent assistance programs in Dallas, just to give you some information on it, are run through the city of Dallas, which then has made grants out to United Way is the primary nonprofit. And so if you ever forget what what the link is to the nonprofit for rent assistance, you can literally just Google DFW United Way rent assistance, and it's the first thing that comes up. And they've got a page on there. And basically what they're doing is they're running a collaborative of about 40 different nonprofits that are out there interacting with the tenants and taking their applications. And there is documentation that has to be provided. And so all those nonprofits process all the applications, and the money comes from Federal CARES Act dollars that are funneled through the city to the nonprofits. So that's important. Just keep that link handy. That's one of the first things I send to people when I talk to them. As I say, go to this website, fill out an application for rent assistance. Some of the programs will pay up to 3 months of rent at $1,500 a month for a maximum of $4,500. Some of them now, some of the newer programs will go up to 6 months. But as far as I can tell, none of them go any longer than that. Here shortly, I think it was intended to go live tomorrow, but my understanding is we don't have the infrastructure set up in Dallas yet, is the governor's office and the Supreme Court have pulled together $170 million of rent assistance through state CARES money. They started a pilot program about a month ago in a limited number of counties. Dallas was not in that list, where they're also doling out money from the state. But if you've already received rent assistance from the city, you get an offset. So if you've gotten 3 months of rent assistance from the city, the maximum under the state program is 6 months. So they're only going to give you the 3 remaining that you haven't already gotten from the city. So it is limited rent assistance. Again, it's November, so a lot of people haven't been able to pay rent since February. So they're 8 months behind. And the 6 months doesn't really do them a whole lot of good. But they still need to apply and see if they can negotiate a deal with the landlord. Some landlords will cut some of the rent or fees or late fees or things like that to try and make some kind of a deal, especially if the tenant has gotten back to work and would be able to catch up or make rent payments if someone helped them get caught up. With that said, we have a small discretionary fund at Dallas Evictions 2020 that we've been raising some money. We've raised about $60,000 so far from various people. We've got an account. Like people decide, we get asked all the time, especially from non-lawyers, how do we help? Well, that's when we help, is to provide money. We have no expenses. We're all volunteers. So the only thing we use that money for is to provide assistance to people that are really in need. And so we will sometimes, if we have to, we'll pay some back rent. Sometimes we'll pay if someone has to move because they just can't work out a deal. We'll help them with moving expenses or paying deposits or first month's rent on a new place. We've spent money delousing children that have horrible lice problems. We've spent money on daycare so that the parents can go back to work. We really use all that money for people that are really in bad need, that need funds on an emergency basis right now, and they don't have time to wait 2 or 3 weeks for the rent assistance programs to come through to save them. One of the other things that we deal with on occasion is if you happen to lose in the Justice of the Peace Court, and by lose I mean even a default, like even if you just didn't show up, you can still appeal that, and you appeal to the county court at law. These are their de novo reviews, and so it's just like you ignore what happened to JP court, and it's a whole new eviction suit in the county court of law. And in order to file that appeal, it's pretty easy. Most of these people are broke, so they're eligible to file a pauper's affidavit, which there are forms for that on the JP's websites. That you just fill out some financial information about the client, name, address, phone number, that kind of stuff, and then have it signed and notarized, although we've gotten away with not notarizing some of them, and then file it with the Justice of the Peace. That that alone starts the appeal process. Generally, I'll file it with the justice of the peace with just a cover letter or notice that just says, hey, we intend to appeal. Here's the pauper's affidavit. And then what they do is they just transfer the case to the county court of law. One of the requirements to perfect your appeal is that you have to pay in 1 month's rent into the registry of the court. And as you might guess, these people are already behind on rent. Most of them do not have money to pay that 1 month's rent to perfect their appeal, which means the technical matter could be dismissed for failing to perfect. So sometimes we have used our discretionary budgets to post that 1 month's rent into the registry of the court, so we can get these appeals through so that people aren't displaced immediately. So how our system works internally here, we are not fancy at all. This was not a planned project. We just kind of fell into this in March, and it's just kind of taken on a life of its own. So we have an email address, which is dallasevictions2020@gmail.com. And then we have basically a Google Voice phone number that I can't recall right now, but it's on our website. And so people can go to our website and fill out a contact form, or they can call this phone number. It's not manned, but they can leave a voicemail, or they can text it, or they can email at our Gmail account. All of those points of contact go into my wife Lauren's laptop, where she takes all that information, does just basic initial vetting just to make sure that this is an email that is about an eviction, because we do get a lot of questions about non-eviction issues that we just respond and refer them out to other legal aid organizations. But as long as it's about an eviction and it's in Dallas County, then she sends that to the next volunteer lawyer in the queue. Once you get that email, then it is your responsibility then to reach out to the tenant, and we'll provide contact information. Especially if they don't give us their contact information, Lauren will call them back or email them back and get a phone number first, so that you don't have to deal with that. But call the client or email the client and figure out what's going on. At that point, you can decide whether there's something you can do to help or not. And by the way, there's a question here about what is the geographic area that we're working with. We're taking cases anywhere in Dallas County, so that obviously is parts of the city, but there's also Garland, Mesquite, some other cities around the edges that we will take cases, because they're all Dallas County courts. So we're not doing anything outside of Dallas County. So no driving to Fort Worth or Collin County or any of those places. But anyway, once the email comes through and she sends it to you, then it's your responsibility to reach out to that client. Now, like I said a minute ago, it's very important that you respond to those emails quickly, just to us, one way or the other, to say, yes, I got your email, I'll call, or I didn't, or I can't help right now, please send it to the next lawyer queue, which is fine. We understand we're all busy people and that happens, but just respond one or the other as quickly as you possibly can, so that we can make sure that these tenants are actually getting into contact with someone that can help them out. One other thing is the email address that Lauren runs, like I said, again, is dallasevictions2020@gmail.com. If you could just go in your spam filters and just clear that email address. We've had some issues with it getting hung up in spam filters and lawyers not getting emails until way too late. So please do that. And then also, Jack, who has been a tremendous help on this project for the last 9 months, is putting up some form documents on our website. So to the extent that you get a case where you need to file something with the JP court, you don't have to invent it from whole cloth or go Google it and figure it out. We're putting those form documents on our website, so you can just go pull them out, fill them in, and submit them. We've also had some requests from paralegals to assist here, and so one of the thoughts are, is if you need someone to prepare a pleading for you, just let us know, and we can send that to one of our volunteer paralegals that can gather that information and actually prepare the documents for you to file, so you can save a little bit of time that way. We don't have a whole lot of paralegal volunteers, but we do have some, so feel free to reach out if that's something that you think you could use. With that really is the presentation. Like I said, we've been in this for 9 months. We've had about 150 volunteer lawyers have come in and out of the program over that 9-month period. And so we've got to constantly kind of refresh our volunteer pool because people do get busy and have other things to do. And so I really appreciate you guys jumping on this Zoom call and listening to me yammer on for a while. And with that, I'll open it up to questions. I see you guys have been asking some questions, and Jack's, as usual, doing a great job responding to them. But if there's something you guys want to talk about or need clarification on, feel free to unmute yourself and ask the question. Well, hearing none. I guess with that, as always, we have finished within 30 minutes. So this is a timely training. I couldn't hear you. Broke up there. You want to try that one?
Question. Hi, this is Monte. Can you hear me now?
I can hear you, yes.
Okay. I guess my question is, this is definitely not my area. Of course, it's something that is easily looked up and I can learn. Is there any lawyers available that could help and assist with any questions that I may have?
Yeah, I'm always on call. And so if you have questions, you send me an email to my law firm email account, which is mark.melton@hklaw.com. And I'm always available. Or call my cell phone, which is 214-908-4829. Or you can also reach out to Jack Fan, and he's just put his email address into the comment section, which is jack@lawoffice.com. And either one of us can answer any questions that you have, and we're always happy to. So don't be shy about reaching out if you've got questions. And you know, to your point, a lot of us are not litigators. You know, I'm a transactional tax lawyer, and so I certainly understand that there may be some trepidation if you're not used to going to court. However, these are usually pretty straightforward cases. It's not a complicated area of the law, and just having someone in the courtroom with them provides a lot of relief. And you just know how to read the law and talk to a judge, and the rules are pretty straightforward. And the real problem that we see is people, A, don't show up to their hearings because they're scared, they don't think there's anything to do, or B, they do show up, they know none of the rules, and the judges are not asking the right questions in a lot of cases to be able to help them get to the right answer, which judges are not allowed to practice law. So it makes some sense. But, you know, I had an issue a couple of weeks ago where, you know, I was doing a hearing about a CDC declaration, and of course we won. And, you know, it occurs to me as I'm looking behind me at the 15 people in the courtroom, in their hands, they're all holding the citation that they got, telling them to come to court. And on the third page of that citation is literally a blank copy of the CDC declaration that all they would have to do is sign it and give it to their landlord right at that moment. And that would have abated the case until January in most circumstances. But even though they're holding this key to freedom in their hands, they have no idea. And so just having a lawyer that is there with them or talking them through it, you know, makes a huge difference, just because they're actually bringing up obvious defenses that will work. They just don't know they should bring up. And they're getting evicted right now, even though there's a CDC order. If they don't provide that declaration, it doesn't apply to them. And so that's why it's important. I see a question here about whether you should be promoting this to the community, and the answer is absolutely. Feel free to share the website, you know, on social media or however you want to do it. It's very important to get the word out, because most of these people they don't have lawyers. They don't know how to ask for a lawyer or where to find us, even though our information is on the last page of that citation that everybody gets. They just don't know what they're looking at. They don't read it through the end to figure this out. Any tips for dealing with JP judges? I can't see the end of your comment here. Who are interested in being helpful. I did essentially depose a judge in court a few weeks ago, where I just asked, you know, out loud, "Hey, judge, is it true that you guys provide these CDC declarations on page 3 of everyone's citation that they're holding in their hand right now?" And she did want to be helpful, and she said, "Yes, we do. And in fact, everyone, you should turn to page 3 and take a look at that thing and see if it applies to you." So there are little things like that. I'm sure that there are judges that would not appreciate that, and so you kind of got to read the room and use your judgment. But I also, sometimes when I go to court, I just walk around before they let us in the courtroom and just go talk to people that look like they're having a bad day and ask them, are you a tenant that's about to be evicted? And I don't represent them because we can't run conflicts that quickly or anything like that. But I will have my stack of declarations in my hand and say, hey, you might look at this. If it applies to you, then you might be able to get out of your eviction. So you might sign it and hand it over while you're in the middle of your hearing. So that's one tip. And I think most people are fairly sympathetic to the tenant's plight here. And so I haven't personally run into any issues with judges yet, but we'll see if that continues. Any other?
Mark, can I jump in on that one?
Yep, please do.
Comment? So I've unfortunately lost an eviction defense case finally, and part of we're kind of doing that that post-mortem debriefing, trying to figure out what went wrong. A lot of our cases in JP courts can be heard. So some of the courts will accept hearings by telephone, and I think for the first hearing, in which if it's the first time that you're presenting the CDC declaration, it's fine to kind of appear remotely. But once you get into a CDC declaration itself, you've got to be there in person, because I think that we lost our case because we were not there in person. And even though it's supposed to be kind of fair, and whether or not you're in person or remotely, you just lose if you're not in person for that actual declaration contest itself. The Texas Justice Training Center actually has a whole set of guidelines, and we'll post it online as well, basically an FAQ to the courts. But not all courts follow those guidelines, because the burden of proof for the plaintiff, the landlord, is on them to show that the declaration is invalid. But I'm telling you, every single judge throws the burden of proof back to the tenant. And it's been so frustrating that it is the tenant's responsibility to defend the declaration and not the judges themselves. So making sure that if there is a contest, make sure that your clients bring every single piece of paper available. We're talking about pay stubs, W-2 forms, 1040s to show their salary, for instance, every single payment that they've ever made, and potentially even talking about their budgets. What else was, also receipts. We were hit so hard at trial because I showed screenshots of applications that were in the process, but then they were like, well, this says not submitted yet. And I was like, and we were trying to argue, wait, this is just an example of what we've done. But they took it as, well, you didn't apply. And it was like, you're kidding me. So if there's a CDC declaration, this is where the new fight's actually going down on, is throwing the tenants with the burden to prove that they've qualified for every single thing on that CDC declaration.
Yeah, I think that's a great point. And one other thing to remember is, the tenant is signing the declaration under penalties of perjury. And so all the things should be true at the moment that they sign them. However, I had a case the other day where the landlord actually proved that he had not applied for rent assistance before he signed that thing. He had applied for it like the next morning, because the timestamp on his email receipt that said thanks for your application was timestamped the next morning. And so, even though that, factually is problematic, I told the judge, and I had a copy of a blank CDC order in my hand. I said, fine, that one may be invalid. Your remedy is to tag this guy with perjury if you really want to. And I handed the new form to my client and said, sign this real quick, and slid it across the table to the landlord and said, Judge, even that first one may be invalid, this one's not. And we're still timely filing it before you issue this. The case has to be vacated or abated. And that worked. She did. So if you've got, some kind of issue with a CDC declaration that was made, prematurely before some of those elements were satisfied, I say, don't worry about it. Satisfy the elements and just give them another one. So there's no rule that says you only get one shot at this. Any other questions? All right. Well, with that, again, you guys feel free to reach out to me or Jack or so. Chris Kersner has offered to be a resource for you guys as well, and his information is in the comments. But feel free to reach out if you have follow-up questions or if you need anything. Also, it would be very helpful because I don't know who all is on this call. If you could just shoot me an email to my law firm account, or actually don't do that. Send it to the Dallas Evictions 2020@gmail.com account so that Lauren can take care of the administrative stuff. And just please send her an email right now to just say, I just did the training. I'm ready to go so that we can get you on our list. Because again, I don't know who all these things get shared and people show up for these things, and I don't know that they're on there, they're not on my list. So that would be very helpful. And if you are returning, if you're an old volunteer that had to step away for a little bit and you're coming back, also send an email and just tell us that so we can get you back on the go list. I would appreciate that. And I just want to remind everybody, this is extremely important work. We are about to drop off a cliff with this eviction issue, especially when these moratoriums are over. And the longer we can keep people housed until we can figure out some kind of solution, likely through the federal government, the better off we're going to be. Otherwise, we're going to have thousands of homeless people living under bridges and on the streets. So thank you for your time today and for participating and for volunteering for this project. And again, just call anytime if you've got questions or comments or concerns. So thanks for joining, and we'll be in touch soon.
Mark, thanks for your leadership. We appreciate it.
Well, I couldn't do it without all you guys volunteering. So thanks, guys. I really appreciate it.
Hey, Mark, I have a question.
Oh, sure. Go ahead.
So the website, the email address that the people need to contact is the Dallas Evictions 2020@gmail.com
That's right.
to get assistance?
Yeah, that's kind of our general intake. So if they want a lawyer, they just email that email address, and then Lauren will take that information and assign it to one of you.
Awesome. I was getting ready to do a Facebook blast, so
Yeah,
I just wanted to make sure it was correct.
Yep, and I use on my social media blast put the website, which is the same, right? It's DallasEvictions2020.com, and
Okay.
then also the email address, so they can hit us from either side. So anyway, so thanks, guys. Any other questions before we go? I'm gonna kill the meeting here in just a second. Okay, thanks so much.